Now, I'd like to welcome you all to the program this morning and thank you for coming. And an extra big hello to our friends in the remote control unit above us. The program this morning has been designed with the idea in mind of dealing very generally with this particular topic, but going through it from its basic beginnings to what many of us hope will never be the end of an estate, and right up into the passing of the accounts. And then we'll break this afternoon and we'll have a panel discussion. You'll see who the members of the panel is, and we'll go on for about half an hour on a panel if you wish to stay that long. Now, you'll see we start with I'll be dealing with fundamental concepts, some of the basic thinking that is behind the equity concept of estate and trust accounting. Then Brian Schnurr will give us some of the nuts and bolts about starting up accounts and how to get them and keep them. Susan Greer will talk to us about preparing accounts for passing, and then we'll deal with executors' compensation and solicitors' fees by Malcolm Archibald. We'll then break for lunch, whereupon we'll talk about an aspect of estate accounting which is not very well understood and which is a matter of some concern to many people, and that is the mingling of estates and companies for the purposes of estate accounting and what information is available to persons involved in both of these concepts when they're complementary one to the other. And then David Fuller will talk to us about some special considerations and some of the practice and procedure that he has encountered in his experience, and to enlighten us to some extent in areas which are not covered otherwise on the program. Now, just before I start my particular area, I'd like to refer you to the case in which the friendly old judge in a gambling case was explaining to the nice little old maiden lady what the game of roulette was all about. And he said, "Now, madam," he said, "roulette is a game that is played with cards." And one of the counsel says, "Balls, Your Honor." Now, that woke up some of those fellows at the back. And we'll talk about some fundamental principles and concepts that relate to executors' and trustees' accounts. Now, while there is a very fundamental difference between the actual duties and, to some extent, the obligations and responsibilities of executors and trustees, in this jurisdiction, unlike the United States, there is really no differentiation, and persons do not differentiate between who is to be their executor and who is to be their trustee. The same person fulfills both functions. As you all know, the executor's function comes to an end when the assets have been gathered in and the trusts set up, whereupon the duties of the trustee then come to be performed, and there is, at that stage, a passing over of responsibility, and of course the usual passing over of accounts and other documents to corroborate what has been done during the first administration. Now, we want to talk about the duties and obligations of executors and trustees within the framework of estate accounting. Now, of course, they have to keep proper accounts, and while that is pretty fundamental and doesn't need to be told to anyone in this particular audience, it is often the case where people start on an administration and don't immediately set up their books and sort of let bills gather and checks gather and bank books all in one file. And one thing leads to another, and the next thing leads to usually a very expensive accounting expenses, whereby you have to call in a chartered accountant to bring things up to date, straighten out the records, try and find the vouchers, and that not only is expensive, and that's to be avoided, but what's more important, that expense should normally be taken out of your compensation as an executor, thought to be devoutly avoided. Now, the accounts, of course, must be kept distinct from other accounts, and a matter, of course, that goes without saying is that we have to keep receipts and vouchers and the various other documents that evidence the transactions that occur during the estate accounting. There's a duty, of course, to produce the accounts to a beneficiary when they may be asked, whenever they ask for them. Now, I don't say they can ask for them every day, but a beneficiary is entitled to ask for an accounting information and whatever is in the knowledge of the executor or trustee on a reasonable basis, reasonably put, so that the executor is given an opportunity to prepare some kind of an accounting. Now, the trustees should, if possible, make sure that the beneficiaries have a copy of the trust deed, the will, whatever is involved with the particular estate, and persons who are specific devisees or beneficiaries should be advised approximately when they may expect their money, what is the state of the account, what is the state of liquidity, and shouldn't, in my view, be allowed to stand around and not be fully apprised of what's going on. I think it's important that a trustee makes the beneficiaries fully acquainted with their rights. Now, it's very important at that stage that the executor or the trustee makes it known to the beneficiary that he's really there to help him, that he's not somebody that's aloof, unapproachable, or someone that isn't there for the best interest of that beneficiary. Now, if you make that clear at the beginning, you'll have a lot less trouble with beneficiaries asking questions. It seems to be that a good many executors seem to go on the basis that if they don't know what you're doing, they don't know what you're doing wrong. That is to be avoided as well. Now, I've got in my list to disclose all breaches of trust. Now, I suppose that's a counsel of perfection, because if there is a breach of trust, you would think that an executor would be reluctant to report it to the beneficiaries. Nevertheless, that's his duty according to law, and if he doesn't report it, and if he doesn't make it clear that he has breached the trust, then, of course, it simply adds to the problems he will encounter when he is being sued for that breach of trust, and it will go very bad for someone who does not fully disclose what has gone on in the way of a breach of trust. For example, someone might say, look, I've held $5,000 in my firm trust account for the last year. I think that might be considered to be something that should be disclosed. Technically speaking, it's a breach of trust. If it's disclosed promptly and at a proper time, most of the time I would think the beneficiaries might say, well, you don't have to put that back. That's all right, we understand. But if you let it go on till the end, you come to the passing of accounts, our friend the official guardian comes down. His duty is to, from what I can see, to get as much as he can for the infants at whatever cost. But at that stage, I think you're going to be in a much more difficult position to explain anything that has technically gone wrong and which ought to have been brought to the attention of the beneficiaries. Now, I realize that if it's a serious breach of trust, if there's theft or something like that, nobody's going to tell anybody, but now you've got to, of course, give the beneficiaries lots of time to read the accounts and to tell them when the accounts are going to be passed. Now, Susan Greer is going to have a good deal more to say about the form of the accounts and what they should contain, but naturally they contain an inventory of what you start with, what you spend, what you take in, what you end up with, and what you've done with the investments. And that's about as basic an explanation as you need, but it doesn't surprise me that that kind of a concept should be simply and easily explained, because it isn't all just lawyers and accountants that are executors and trustees. Many persons who have no legal knowledge and little or no accounting knowledge are often executors and trustees and perform the function extremely well, including the preparation of accounts once it's described to them just precisely what they're supposed to be doing. Now, there's two aspects of passing of accounts and accounting duties of an executor that I'd like to deal with. In the broad sense, the function of an executor or trustee is to administer the estate to the best of his ability so as to maximize whatever can be maximized in the circumstances. And it's this type of performance that is essentially the kind of accounting that is most meaningful to beneficiaries. Now, that's the accounting in the broad sense. And it's the kind of accounting that we think of in the way of interim financial statements that are presented to beneficiaries on whatever annual or other basis that you decide to do. And it shows the profit and loss, or the profit, we hope never a loss, but it shows the profit that has been achieved by the executor trustee and how he has performed. Now, that's the broad sense of accounting. The narrow sense of accounting is what we deal with in our area on a passing of accounts. It's really basically an audit. It's a collection of entries which are substantiated by vouchers or other records to corroborate those particular entries, and it's purely and simply performed for the purpose of releasing a person from his responsibility for accounting for that period up to that time. And usually it is done in the same context as someone who comes in to audit your books. Your auditor comes in to audit your books every year. He wants vouchers. He wants proof that the various checks were signed, various bills were paid, accounts received, and it's just basically the audit function that we're primarily concerned with today. But it's in the broader context that you have to consider your responsibility as an executor and trustee, and it is not simply good enough to keep your records and not attend to the ongoing work of the proper investing of the estate. That has to be reported to the beneficiaries as well as the kind of audit or passing of accounts. I don't know what the practice of trust companies is. I suppose it depends on the size of the estate, but I understand most executors who are experienced in the field provide at least an annual statement for beneficiaries prepared on the performance basis to show them what has happened during the year. And then every 5 years or so, they have what we call the court audit, or the passing of accounts, which we're here to discuss today. Now, it's really a very simple format, accounts. You'll see the accounts, and when I deal with them as we go along, it's very simple if you just think about it. It's ins and outs, and that's all. It's a record, it's not performance. So the thing to remember, of course, too, is once you have passed your accounts, they never have to be passed again for that period. You don't have to account for that period again unless there's a fraud or a mistake, which of course, would vitiate any particular accounting. But they're well known to you all, and the form is not one that is not familiar to almost all the profession. Now, we've got just exactly what is a standard that should be achieved in preparing accounts, and I think the American College of Probate Counsel has probably given the best definition, and it's the standard that they suggest is that they should be capable of being understood by a person of average intelligence, literate in English, and familiar with basic financial terms. Now, so far we all qualify, but then it goes on to say who has read it with care and attention. And that's where we usually fall down. That's where lawyers fall down who are asked to represent beneficiaries on passings, and that's where beneficiaries fall down. They just can't be bothered to sit down and read the accounts with care and attention. And if you do spend some time on accounts, they don't appear to be nearly as difficult as they first appear, because there are a large number of entries in many of these particular accounts that are passed. You should be careful also to avoid comments or definitions such as debits or credits, other accounting concepts that are not generally known to persons who don't have some bookkeeping or accounting experience. Now, I want to turn to the accounts themselves, and you'll see there's a sample set of accounts in the back of your, just behind my notes. I'd ask you to turn to them. Now, I just want to make a couple of suggestions that might improve these accounts. These accounts were prepared by Brian Schnurr. They're excellent. It's an excellent set of accounts prepared for the bar admission course, but I just like to think that perhaps there are some things that we ought to think about. I know most of us will never do it, but it's important, I think, that we at least discuss them with a view to upgrading or improving the standard of practice if that can be done. I think there should be a statement on these accounts, as I state in my notes, that something as to what the trustees are trying to do. The trustees are presenting these accounts to the judge for approval and to acquaint interested parties with the administration of the estate and its proposed distribution. I suppose that's a little bit of advertising that we normally wouldn't put on these particular accounts, but because of the sort of austere way in which lawyers are regarded, I think it should be done with a view to letting people know that they're easily understood, and this is the purpose of it. The other points that I raise are very simply that someone ought to be designated on the front of the schedule as to who's available to discuss these accounts. I suppose it goes without saying that perhaps the beneficiaries would know who Sarah, Samuel, Nicholas are, but they would probably be referred to someone else to explain the accounting, and I think that's a note that ought to be put on the front page. Next, we see the next item, of course, is an index of the various entries and accounts. And then we turn over to a summary, which is the capital account, ins and outs, investments, revenue accounts, ins and outs. We then turn on page 2 of the accounts to the inventory. It's important, I think, in discussing and putting what's to be in the inventory, that the inventory be spelled out in reasonable detail. Now, I don't think you have to provide share certificate numbers or bond numbers, but I do think that you have to make sure that persons know with some degree of particularity what was in the estate at the beginning and what was in at the end. There's a point that I think should be made, and these accounts don't disclose it, and that is that I think there ought to be a market value, a present market value indicated on the particular accounts to indicate what the market value is as opposed to what the asset was taken into the estate at, so that persons have a more realistic idea. You can imagine how ridiculous it looks to see a value of a 6-bedroom house in North Toronto in the assets as a $30,000 investment. I think persons who aren't familiar with what has transpired in this city and real estate, and many other cities as well, would be misled by those particular figures. Capital income, revenue receipts, of course, are simply set out in the accounts themselves, and they require no explanation. The investment account is an account that I would like to just dwell on for a while. That's found on page 18 And you'll see that that is simply a record of all of the transactions which took place in the estate of an investment nature, buying and selling of bonds and stocks. And you'll see that there is a designation, sale, purchase, and what they were purchased for. Then we come to the executor's compensation, statement of executor's compensation. And of course, there's no hard and fast rule, but there is a hard and fast rule. It's 2.5% in and 2.5% out, and 2/5 of 1% per annum on the average value of the estate. That you'll see is set out in the accounts. And of course, it's something that should be very carefully and accurately spelled out, so that when it comes time to pass these accounts, there's no question as to what the executors are asking for and on what basis. Now, of course, if you do something special, if the estate is one of above average complexity, then of course the executor or trustee would be entitled to more than what would be ordinarily provided for compensation. Now, I think the most difficult problem is the complaints that can be lodged against an executor or trustee for some of the arrogant behavior that's conducted in this particular office. But we'll talk mostly about claims that are actionable. Most of the time, the claims made against an executor arise out of negligence, quasi-negligence, lack of professional or whatever standard of care is required of the executor. And I think you should know now that if you do perform a negligent act, and if you are liable, your errors and omissions insurance won't cover you in your capacity as an executor. So that it's well to bear that in mind when you take on this office, because it's becoming increasingly more popular as time goes on to sue lawyers, not only as lawyers, but in any other way he can be sued. And as a trustee or executor of an estate is a very popular game these days. Unfortunately, it's not popular enough, but it's extremely important to remember that you've got to be careful, and you'll find, of course, the judge will, on a passing, will have the facts put before him. How he deals with it, of course, is up to him. He may decide to formalize the proceedings, require statement of claim, statement of defense, and pleadings, discovery, or he may simply investigate, as he's entitled to do under Section 73, into the claims, and they will be determined at the time. And of course, he can surcharge or falsify the executors and give whatever judgment he sees fit, by way of damage or by way of replacing an asset that has not been properly reported, or some income from which has not been put into the estate. Now, just what are the nature of these particular complaints that occur? Well, the investment of funds is frequently, and I suppose the most common, complaint. The executors are blamed for not getting out of bonds at the proper time. They're subject to complaints because there's still inequities. They're subject to complaint because they bought a GIC 5 years ago that yields 10%. That kind of complaint may or may not have some validity. Nevertheless, if you are required to account, those are the kind of complaints that will arise, and some are actionable and some are not actionable. The failure to provide a mix of assets is really not as popular or as common an occurrence as the failure to use some asset in some certain way. However, as you all know, it's the duty of the executor and trustee to make sure that the remainder interests are balanced with the intermediate income interests. negligent investment is not an uncommon complaint. A complaint often arises when an executor invests in a speculative stock. And if that speculative stock goes down, then, of course, he's a subject matter of some complaint. If it goes up, of course, there'll be no objection. The nice problem then is, does he have the authority to invest in the particular speculation? It's difficult to conceive, really, of a situation where an executor would be authorized to deal in speculative shares under the terms of a trust. The degree of speculation, of course, usually isn't spelled out, but I warn you to beware of the particular part of the will which says that either the executor has unfettered discretion or he is not liable for any errors or loss that the estate suffers as a result of his investments, because they mean absolutely nothing when it comes to the bottom line. If the executor has exceeded his jurisdiction, he will certainly have exceeded his authority and jurisdiction if he invests in stocks of a speculative nature. Executors have to be careful as well, because there's another area which maybe is not as popular or well known as others. That's the new method of complying with the Income Tax Act, the various returns that can be filed. There must be prompt filing so that penalties aren't incurred. There must be proper consideration taken into account as to elections and those kind of things under the Income Tax Act, because they are becoming the subject matter of complaints, and in one instance that I know of, an actual claim against an executor for not having exercised the proper election. There's the main complaint, though, is the delay beneficiaries are experiencing with respect to either receiving their income or receiving the bequest or devised under the will. Now, it takes time, and executors must not be rushed, they must not be hurried, but they must be reasonable. And so it is that one must take care to ensure not only that one doesn't become negligent by reason of the delay, but it is desirable that if he's to maintain that office and to maintain some kind of a relationship with the beneficiaries, that there be some degree of promptness in dealing and reporting to these beneficiaries. Now, I'd like to deal now with surcharging and falsification of accounts. That's simply where someone says, and it's all defined in my notes, someone says there's something there that shouldn't be there, or there's something not there that should be there. That's the kind of problem that really we've been dealing with all along, and it's the subject matter of most of the complaints that can be raised in an estate passings before a judge on an audit. Sometimes, of course, there's, as I point out, there's a problem with incorrect recording of entries. They can, of course, simply be reversed or changed in the normal course, but I give the example of a dividend from a company to its shareholders from accumulated surplus, and that question is whether that dividend is paid in account of income or capital. It can be a very difficult one and can have some very real significance to the different beneficiaries who are involved in the particular estate. Now, that is the extent of what I manner in which I propose to introduce this program on a general basis.